Hello guys, and welcome back to another episode of my lecture. On today's episode, we will be discussing section 6, subsection 1 of the Evidence Act. In my last episode, I discussed section 5. And in my section 5, I told you that where a thing has occurred, occurrence A, the cause of occurrence A itself, and the effect of occurrence A is admissible in court as part of relevant fact evidence. And on today's class, we're going to be talking about motive, preparation, previous and subsequent conduct of a person. So let's go straight to section 6 of the Evidence Act. So what does section 6 subsection 1 of the Evidence Act, which we'll be discussing today, state? It states that any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant facts. Now, any fact which shows motive or preparation for any fact in issue is a relevant fact. When we look at the case of OGUNTOLA versus the state, the court stated that as the reason for an act, that is, what propels a person to do an act, evidence of motive may be seen in form of envy, revenge, anger, passion, selfishness, ambition, etc. Even though motive may not be an element of an offense, fact evidencing motive may be deemed relevant and admissible. In the case of ISHOLA versus the state, clash between the accused and the deceased eventually led to the death of the deceased. Counsel gave evidence of accused poor hostile visitations in the area, and this was objected to. The court held that this was admissible under section 6 as it shows intent to commit murder even though motive was not an element of the offense. In the case of ATAMO versus Attorney General of BENDEL State, the senior manager entered the bank after working hours and locked the entrances. Fire gutted the building and he escaped the building. It should be noted that the bank was being investigated in a case of fraud. The manager went to the premises of the bank and sent the security man to put on the gen. His defense was that there was a power surge. The court rejected the defense and construed that he had intention to burn the building. In the case of IYARO versus the state, the accused cabman carried passengers and deviated from the normal route. He blew horn so that people would come out of the bush to rob them and ran away. The court held that this was motive and intention. In the case of NWEKE versus the state, the husband was arraigned for the offense of killing his 8 months pregnant wife. The evidence against him was the way he badly treated his wife and even denied the pregnancy. The court held that this was motive and therefore relevant. So yes, right now we are talking about not the cause of occurrence A and not the effect of occurrence A. The cause of occurrence A is what happened before a particular thing. The effect of occurrence A is what happened after a particular thing. But here we are looking at occurrence A and we are looking at the motive behind occurrence A. We are not looking at what are the steps that could have been taken. We are not looking at what happened after it. We are looking at what was the motive of occurrence A. And according to section 6 of our Evidence Act, it tells us that the motive of occurrence A is very important. Anything that shows motive or anything that shows preparation is very important. So, and then OGUNTOLA versus the state, the court there gave us some things to look at, some things to weigh in on. Told us that we should look at envy, we should look at revenge, anger, passion, selfishness, and so. And while we are looking at what OGUNTOLA versus the state has told us, we then have to look at how they played out in the case of JIMOH versus the state, where anger played out. Now in JIMOH, The concurrence A there is that there was a murder case. Somebody had died, and then JIMOH ISHOLA is on trial, being the accused. And then what are the things that you are supposed to bring as evidence when you are a lawyer? The fact in issue is that they must have caused grievous bodily harm, and then the person had intention to cause grievous bodily harm. But then the other party was bringing things such as the hostile visitations of JIMOH ISHOLA. I mean, the hostile visitation of a person to another person's house should not be the subject matter of a trial. It should not be put into evidence. But the court stated that yes, it is not the element to be proven in this case. We know that. But then it is like a torchlight that shines light on certain other things that we need to know. Do you understand? Motive is like a torchlight. Preparation, that's section 6 of section 1, is like a torchlight that shines light into other things that we need to know. Okay, so this person have done this before, done that before, done this before. It means that he is likely to have. Do you understand? So if we look at our next case, let's go a little bit to the case of NWEKE versus the state, where the man there had killed his pregnant wife, or at least was alleged to have killed his pregnant wife. Now, what is our torchlight in this case? Our torchlight is the fact that this guy in question had been beating his wife before her resultant death. That's number one. Number two, which is like a kicker here, is that he also denied the pregnancy. He denied the pregnancy. He has been beating his wife. His wife resulted to be dead. Although the prosecution still has to prove the two important elements, the mens rea and the actus reus. The actus reus being that he must have caused grievous bodily harm, and the mens rea means that he must have intentionally caused it. If it was negligence or recklessness, that would be manslaughter and not murder. So in this case, the prosecution still has to prove those two elements. However, what will help us eliminate the whole element to be proven would be that he had been beating his wife. Do you understand that? So see motive like a torchlight. See preparation like a torchlight. Torchlight does not do the job for you. Imagine you need to read in the night and then you put on torchlight and say, yes, I'm reading. No. It just helps you illuminate things to look at, things to see. Torchlight illuminates what we are supposed to do. It does not point those things out to us. While we've illuminated it, by putting on the torchlight of motive and preparation, we ourselves still have to bring out the element of actus reus and mens rea. So, in the case of ATAMO versus Attorney General of BENDEL States, the bank is being investigated for fraud. And the bank manager knows that if they come to the bank to come and pick certain papers in the bank, that certain things will happen. And they will catch them. The bank manager knows that. So the bank manager went outside. He got to the bank one day and then he went out. He told the gate man to go and put on the chain. He purposely did that so that he can burn down the bank. Now, there are two cases here. We have the case of arson. It is not the case of arson we are talking about here. We are talking about that fraud case. Under the fraud case, we can still bring this fact that he had burnt the evidence in the fraud case to show that there is motive for something. Do you understand that? This motive here is brought for our fraud case, that there is motive to hide something, and there can only be a motive to hide when there is fraud. However, do note that the fact that he burnt the whole place down does not mean that fraud has been committed, because the court cannot then send him to jail on the count of fraud for burning the place down. That is what I'm saying. But then it on the torchlight to us, we can say, so bank manager, you burnt down the place. If you have nothing to hide, you will not burn down the place. Do you understand? So when the torchlight has been on, it gives us more light. It illuminates the whole place for us to search even deeper. There is something. And then we will then bring out the elements for our case of fraud. Do you understand? And that then brings us to the last one, the case of IYARO versus the state. In the case of IYARO versus the state, the accused cabman carried passengers and deviated from the normal route. He blew on so people would come out of the bush to rob the passengers, and they ran away. The court held that this was motive and intention. Now, if you are in Lagos, you would know that because of traffic in Lagos, most people usually do not pass the normal route, especially buses and danfo. They always pass the other, some other places which we know as shortcuts. When I'm in Lagos and they are currently passing those places, I usually do not have any problem. But if I were to travel interstate and they are not passing like the normal expressway, they are beginning to pass corner, then I start speaking in tongues. Hey, Jesus Christ, where is he going? Because I do not know where you are. Because I do not know the route. Do you understand? In Lagos, you can do weary for them. But yeah, I'm going from Lagos to Ife, and you're already passing corner. Where do I know? Now, you see, the corner in itself is no problem, actually. Because yes, you can decide to innocently avoid certain things. But then, he then decided to blow a whistle. All of a sudden. Wow. Mr. Driver, you have turned to referee. You decided to blow a horn. Do you understand? So now, in this case, note that the fact that he left the route is not a crime. The fact that he blew on is not a crime. On a normal day, it's not meant to be admissible. But because, like I told you, section 6 subsection 1 is what I call the provision of torchlights. It helps us to look at things with a broader perspective, with more light, and helps us illuminate things for us to understand. Because now that you know that there has been a blowing of whistle, and you know that the route, the normal route wasn't followed, it helps you connect the dot of, okay, it is because he wanted them not to be in the place where people can save them, but to take them to the den of the armed robbers where they'll be able to take them. Do you understand? Although it doesn't prove in itself that the driver is guilty, but it helps us illuminate certain other things. Do you understand? So that is that for section 6 subsection 1. However, we are going to look at section 6 subsection 2 and section 6 subsection 3 in my next class. I hope you've enjoyed today's class, and in case you have any question, you can kindly put it in the comment section below. I will see you in my next class.